I'm your host, Mark Reel. This is State of the Family Courts, and we have we'll call him a reoccurring guest coming back on today. We have Ted Bush from the state of Illinois. Ted, how are we doing today?
I'm doing great, Mark, and thank you for inviting me on the Real Fathers Rights Movement. I love your show. I watch it every week, and I hope you're not taking your entire brand away, but I consider myself to be on the Real Fathers Rights Movement show right now.
Thank you. I appreciate that, and I wanted to get you back on. We've kind of had a reoccurring theme here. I would say over the last 6 weeks, there's been a lot of discussion, a lot of movement in terms of family court and what can happen and what's occurring right now in federal court. And I know you and I have had some conversations at length. You're someone who actually personally has had some success in carving some things out at the federal level. So we talked a little bit before the show. I had Ryan on last week, and the state of Minnesota is a little bit wonky, a little bit weird, where they actually put percentages, they actually put numbers statutorily on their books. So it kind of opens them up to some unique arguments, and Ryan and I discussed those. So I guess we'll start out with yours. Yours is more of a general playbook that in theory isn't a class action, but could be used in almost every single state. So the first thing I kind of want to do is, for the viewers, explain a little bit about kind of what your theory is on how individuals could be successful in federal court right now.
Well, I think that when we're addressing federal court, okay, just for right now, just forget money. Okay, so if people are out there saying I've been wronged and I want to get compensated for what has happened to me, and you deserve compensation, but you're not going to get it from federal court right now, almost certainly in your jurisdiction. More than likely, the judges are considered state actors, meaning they're subject to immunity. So you're not going to be able to get them. More than likely, maybe in some cases they're considered county actors, where you can sue the county. You might be able to get damages, but just put that all aside right now about your individual cases, because we're talking about the movement and we're making sure that the next generation doesn't go through what we've gone through. We're trying to change the policies and the practices and the things that have happened to us that bring us together, the common abuses that continue to happen. Those are the things that we're addressing here in this rubric, and that's what Ryan is dealing with. But like you said, correct, I love Ryan's ideas, and they are absolutely applicable in that case, because Minnesota opened themselves up to a mathematical formula, and his arguments are very, very well sound arguments. I enjoyed listening to them. But yes, in order to sort of get everyone together, to build together, there are a lot of things that can bring us together when we talk about federal court. In order for that to happen, that we need to change the discussion a little bit to what exactly we would be challenging as a group.
And so what is that, in your opinion? What's at the core? What I guess we'll start out with, what have you challenged, and then what do you think the next steps are to continuing to chip away to have success in federal court, to more narrowly construe the domestic relations exception? What's that core for our movement in the macro?
Yeah. Well, what I'll do right now, okay, just so your viewers are aware, is that you've got your state court system where you've got your circuit courts, or in New York you have a Supreme Court, then you have an upper appellate court, then you have, and sometimes you have, in some states, district circuit courts. Everyone knows their state court system. Okay, in the federal court system, we have district courts all over the country, every major city divided into the states, and then we have 13 circuit courts of appeals that cover multi-states. So at Illinois, we've got Illinois, Wisconsin, and Indiana. And in the Ninth Circuit, you've got California, Washington, Oregon, and Arizona, a bunch of lots of states, huge circuit. Okay, so the law is different in each of these 13 circuits. So you're in Florida, someone's law could be different than someone's in California. And it's actually markedly different sometimes. Okay, so the first thing in order to get into federal court is that you have to convince the federal court that they have jurisdiction. And there are a lot of things that keep us normally out of court. Now, what's happening, and what I'll talk about, my little victory that I had in the Seventh Circuit, where I got a federal judge now and the circuit to finally acknowledge that they have subject matter jurisdiction over these issues. anything involving domestic relations. In Illinois, I fought the state attorney general because the state attorney general was, to this day, arguing to the federal judiciary that anything involving domestic relations was excluded from the jurisdiction of the federal courts. Anything involving, they literally did this, Mark, involving, okay, which would involve, I mean, these people are mostly liberals, would include gay marriage. So their argument is like what Kwame Arul made in Illinois when I was fighting him in federal court. He was breaking his campaign promises because he campaigned on gay marriage. And he was then taking the position of the Eagle Forum, which opposed the Obergefell case and recognized rights for, you know, millions of people that if anyone was against, they would be thrown onto the street and tarred and feathered. Okay, that is so settled. You know, those federal rights right there involving federal rights to, you know, to let's say same-sex marriage. But that is the extreme amount that these states are arguing, and that is not the law. And what happened in my case is that the Seventh Circuit reaffirmed, no, this is very narrow, is that we can hear these claims, constitutional claims, if there's unconstitutional behavior by anybody. We can hear them as long as the plaintiff is not seeking a divorce, a child custody order, an alimony order, or a division of property. As long as you're not doing those core dissolution of marriage and custody issues. If something happens along the way, or there's, you know, your constitutional rights have been violated by anybody, they can hear it. So just quickly, so back to the circuits. Okay, so we got 13 circuits, and what the state of the law is on the circuits is that it's really not formed. That there, like for example, in a few circuits, like the Fifth Circuit, which is Texas. There's an unpublished opinion from years ago where they sort of resolved the same issues. Yeah, we can hear these cases. The abstention doctrines, the Rooker-Feldman doctrines, the domestic relations exceptions, they don't apply. But a lot of them, because what happens is that these cases aren't brought by normal attorneys. They're brought, often they're just pro se, and there's usually a defect in them. So that the law out there are mostly unpublished, unknown cases where they sort of get it, but not quite. There are a few circuits where it's published, like the Ninth Circuit. And Mark and I, you and I, we talked about this case, Cook versus Harding from 2016 from the Ninth Circuit, where I think in your jurisdiction, this is resolved as well. In the Seventh Circuit, it's resolved is that they can hear these cases. And I've seen cases in the Sixth Circuit. I've seen, you know, a little bit here and there, but very few have confronted this head on. So it's extremely important that we've gotten, at least recently in the JV versus Woodard case, the ability, at least in these three states that I have, for the federal courts to admit they have subject matter jurisdiction. That is number one. So we can't do anything until we establish that.
And let's kind of dive a little bit deeper, I guess, more on the surface level of that. You mentioned Rooker-Feldman, the domestic relations exception. Essentially, what we had nationwide is that courts had been very liberal in the application of it. Anything, and essentially you had, and states are fighting for this, anything involving domestic relations courts, family courts, whatever they're referred to in your state, anything involving those, if it occurred in family court, oh, domestic relations exception.
Mm-hmm.
Oh, it's been litigated out already, Rooker-Feldman. And what these cases are doing, it's not changing the law at the state level, but it's shaping federal law, which states have to follow, that are going to allow for bigger things to come in the future. This is not an issue at the federal level that right now we're going to be able to attack head on. Going to have to get wins in multiple district courts or multiple circuit courts in order to more narrow these exceptions and to allow us to get cases into court when there have been constitutional violations.
I think that's largely accurate, but I think any circuit in this country, including that has no even unpublished opinions on this, that you could survive a motion to dismiss if you have an honest judge, an honest federal judge. I don't think there's anything holding us back, but this is what happens all the time, Mark. And I used to work in Washington, where the law was clear, but the bureaucracy wasn't following it, so you had to file a bill to do it anyway, even though the law is already clear. Like you've seen that before, and that's what's happening now. Yeah. They're just making us go through the motions. So we'll go through the motions. The bottom line is that this is such a conflict of interest, Mark. is that the state attorney, there is nobody looking for justice on these federal issues. Nobody in the state attorney general's office. In Illinois, they just defend the defendants, the state defendants. They just reflexively go into them as if they're the defense attorney, and they're not looking at, wait, what's going on here? Like, can we step in and can we, resolve something like this? They are a partisan against you, when in fact they could come in independently and file their own motions and make their own cases and say, no, yeah, we do have a problem. We do need to make some changes here. There's that, at least in Illinois and most, that's your enemy is the state.
You mentioned it. The attorney general came in and in a state that is consistently blue, literally came in and took a position that the 2015, I was in law school when Obergefell, the ruling came down. So that was an entire year of con law. Like, they're going in this well settled, pretty much agreed upon by, I would say, 95% of the country, at least at this point, that's what the law is. We're cool with that. They're coming in and making an argument that directly contradicts it just to defend this small point.
Oh, what their analysis, it would take us back 50 years. Okay, Stanley versus Illinois obviously came out of Illinois in 1972. It is one of the most famous cases that every single one of your viewers should read. It is an easy case to read. You pull up this case and you read it, and you read how egregious it was that in 1972, 50 years ago in the state of Illinois, if you were an unmarried father and the mother became incapacitated, you lose custody of your children without a hearing. They go up to adoption without even a hearing. And that went up to the Supreme Court. That involved domestic relations. Well, you want to know what also include domestic relations? Loving versus Virginia, interracial marriage, Palmer versus Sidoti, racial discrimination in custody decrees. Okay, all these cases going back that have established fundamental rights, these state attorneys general are trying to destroy because they are so committed to protecting their own financial interests, meaning being sued.
Yeah, and when you bring it up like that, I mean, those are some of the most well-known Supreme Court cases. I mean, the Loving case has its own feature film
Right.
about it. And it kind of flies in the face. So I think that goes back to I think one of the big movements. I think I want to give a shout out to Casey Sowers, the executive director. I think he's done a phenomenal job of trying to change the narrative. The opposition of this wants to paint is it's the angry dad, it's the deadbeat dad. This is not someone that we need to pay attention to. This is just someone that's acting irrationally. This is someone that's acting emotionally. They're not fit. They're just trying to get out of child support. And when you start to look at it, those cases are extremely comparable. They were individuals that at the state level were being stripped of rights, were being stripped of due process. And many people opposed it at the time. And now we look at it and it's just common sense.